Employment discrimination law in the United States. Employment discrimination law in the United States derives from the common law and is codified in numerous state, federal, and local laws. These laws prohibit discrimination based on certain characteristics or protected categories. The United States Constitution also prohibits discrimination by federal and state governments against their public employees. Discrimination in the private sector is not directly constrained by the Constitution, but has become subject to a growing body of federal and state law, including the Title VII of the Civil Rights Act of 1964. Federal law prohibits discrimination in a number of areas, including recruiting, hiring, job evaluations, promotion policies, training, compensation, and disciplinary action. State laws often extend protection to additional categories or employers. Under federal employment discrimination law, employers generally cannot discriminate against employees on the basis of race, sex including sexual orientation and gender identity, pregnancy, religion, national origin, disability physical or mental, including status, age for workers over 40, military service or affiliation. List of United States federal discrimination law. Equal Pay Act of 1963, Civil Rights Act of 1964, Title VI of the Civil Rights Act of 1964, Title VII of the Civil Rights Act of 1964, Executive Order 11,246, Age Discrimination in Employment Act of 1967, Education Amendments of 1972, 72, Title IX, Rehabilitation Act of 1973, P3, Vietnam-era Veterans Readjustment Assistance Act of 1974, Age Discrimination Act of 1975, Americans with Disabilities Act of 1990, Genetic Information Non-Discrimination Act of 2008. Constitutional basis. The United States Constitution does not directly address employment discrimination, but its prohibitions on discrimination by the federal government have been held to protect federal government employees. The Fifth and 14th Amendments to the United States Constitution limit the power of the federal and state governments to discriminate. The Fifth Amendment has an explicit requirement that the federal government does not deprive individuals of life, liberty, or property without due process of the law. It also contains an implicit guarantee that the 14th Amendment explicitly prohibits states from violating an individual's rights of due process and equal protection. In the employment context, these constitutional provisions would limit the right of the state and federal governments to discriminate in their employment practices by treating employees, former employees, or job applicants unequally because of membership in a group such as a race or sex. Due process protection requires that government employees have a fair procedural process before they are terminated if the termination is related to a liberty such as the right to free speech or property interest. As both due process and equal protection clauses are passive, the clause that empowers Congress to pass anti-discrimination bills so they are not unconstitutional under 10th Amendment is Section 5 of 14th Amendment. Employment discrimination or harassment in the private sector is not unconstitutional because federal and most state constitutions do not expressly give their respective government the power to enact civil rights laws that apply. The federal government's authority to regulate a private business, including civil rights laws, stems from their power to regulate all commerce between the states. Some state constitutions do expressly afford some protection from public and private employment discrimination, such as Article I of the California Constitution. However, most state constitutions only address discriminatory treatment by the government, including a public employer. Absent of a provision in a state constitution, state civil rights laws that regulate the private sector are generally constitutional under the police powers doctrine or the power of a state to enact laws designed to protect public health, safety, and morals. All states must adhere to the federal civil rights laws, but states may enact civil rights laws that offer additional employment protection. For example, some state civil rights laws offer protection from employment discrimination on the basis of political affiliation, even though such forms of discrimination are not yet covered in federal civil rights laws. History of federal laws. LGBT employment discrimination. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination on the basis of sexual orientation or gender identity. This is encompassed by the law's prohibition of employment discrimination on the basis of sex. Prior to the landmark cases Bostock v. Clayton County, Georgia, and R.G. and G.R. Harris Funeral Homes, Inc. Prior to the Bostock decision, the Equal Employment Opportunity Commission (EOC) interpreted Title VII to cover LGBT employees. The EOCs determined that transgender employees were protected under Title VII in 2012 and extended the protection to encompass sexual orientation in 2015. According to Crosby Burns and Jeff Krefli, studies show that anywhere from 15% to 43% of gay people have experienced some form of discrimination and harassment at the workplace. Moreover, a staggering 90% of transgender workers report some form of harassment or mistreatment on the job. Many people in the LGBT community have lost their job, including Vandy Beth Glenn, a transgender woman who claims that her boss told her that her presence may make other people feel uncomfortable. Almost half of the United States also have state-level or municipal-level laws banning the discrimination of gender non-conforming and transgender people in both public and private workplaces. A few more states ban LGBT discrimination in only public workplaces. Some opponents of these laws believe that it would intrude on religious liberty, even though these laws are focused more on discriminatory actions, not beliefs. Courts have also identified that these laws do not infringe free speech or religious liberty. State law. State statutes also provide extensive protection from employment discrimination. Some laws extend similar protection as provided by the federal acts to employers who are not covered by those statutes. Other statutes provide protection to groups not covered by the federal acts. Some state laws provide greater protection to employees of the state or of state contractors. The following table lists categories not protected by federal law. Age is included as well, since federal law only covers workers over 40. In addition, District of Columbia matriculation, personal appearance, Michigan height, weight, Texas participation in emergency evacuation order, Vermont place of birth. Government employees. Employees of federal and state governments have additional protections against employment discrimination. The Civil Service Reform Act of 1978 prohibits discrimination in federal employment on the basis of conduct that does not affect job performance. The Office of Personnel Management has interpreted this as prohibiting discrimination on the basis of sexual orientation. In June 2009, it was announced that the interpretation would be expanded to include gender identity. Exceptions. Bona fide occupational qualifications. Employers are generally allowed to consider characteristics that would otherwise be discriminatory if they are bona fide occupational qualifications BFA. For example, a manufacturer of men's clothing may lawfully advertise for male models. Religious employment discrimination. Religious discrimination is treating individuals differently in their employment because of their religion, their religious beliefs and practices, or their request for accommodation, a change in a workplace rule or policy of their religious beliefs and practices. It also includes treating individuals differently in their employment because of their lack of religious belief or practice. According to the U.S. Equal Employment Opportunity Commission, employers are prohibited from refusing to hire an individual based on their religion, alike race, sex, age, and disability. If an employee believes that they have experienced religious discrimination, they should address this to the alleged offender. On the other hand, employees are protected by the law for reporting job discrimination and are able to file charges with the EOC. Some locations in the U.S. now have clauses that ban discrimination against atheists. The courts and laws of the United States give certain exemptions in these laws to businesses or institutions that are religious or religiously affiliated, however, to varying degrees in different locations. Depending on the setting and the context, some of these have been upheld and others reversed over time. Members of the Communist Party. Title VII of the Civil Rights Act of 1964 explicitly permits discrimination against members of the Communist Party. Military. The military has faced criticism for prohibiting women from serving in combat roles. In 2016, however, the law was amended to allow them to serve. In the article posted on the PBS website, Henry Louis Gates Jr. writes about the way in which black men were treated in the military during the 1940s. According to Gates, during that time the whites gave the African Americans a chance to prove themselves as Americans by having them participate in the war. The National Geographic website states, however, that when black soldiers joined the Navy, they were only allowed to work as servants. Their participation was limited to the roles of mess attendants, stewards, and cooks. Even when African Americans wanted to defend the country they lived in, they were denied the power to do so. Unintentional discrimination. Employment practices that do not directly discriminate against a protected category may still be illegal if they produce a disparate impact on members of a protected group. Title VII of the Civil Rights Act of 1964 prohibits employment practices that have a discriminatory impact unless they are related to job performance. The Act requires the elimination of artificial, arbitrary, and unnecessary barriers to employment that operate invidiously to discriminate on the basis of race, and, if as here, an employment practice that operates to exclude Negroes cannot be shown to be related to job performance, it is prohibited, notwithstanding the employer's lack of discriminatory intent. Height and weight requirements have been identified by the EOC as having a disparate impact on national origin minorities. However, when defending against a disparate impact claim that alleges age discrimination, an employer does not need to demonstrate necessity, rather, it must simply show that its practice is reasonable. Enforcing entities. The Equal Employment Opportunity Commission (EOC) interprets and enforces the Equal Pay Act, Age Discrimination in Employment Act, Title VII of the Civil Rights Act of 1964, Title I and V of the Americans with Disabilities Act, Sections 501 and 505 of the Rehabilitation Act, and the Civil Rights. The Commission was established by the Civil Rights Act of 1964. Its enforcement provisions are contained in Section 2000-5 of Title 42, and its regulations and guidelines are contained in Title 29 of the Code of Federal Regulations, Part 1614. Persons wishing to file suit under Title VII and/or the ADA must exhaust their administrative remedies by filing an administrative complaint with the EOC prior to filing their lawsuit in court. The Office of Federal Contract Compliance Programs enforces Section 503 of the Rehabilitation Act, which prohibits discrimination against qualified individuals with disabilities by federal contractors and subcontractors. Under Section 504 of the Rehabilitation Act, each agency has and enforces its own regulations that apply to its own programs and to any entities that receive financial assistance. The Office of Special Counsel for Immigration-Related Unfair Employment Practices (OSC) enforces the anti-discrimination provisions of the Immigration and Nationality Act (INA) 8 U.S.C. SS 1324, which prohibits discrimination based on citizenship status or national origin. State Fair Employment Practices (FEP) offices take the role of the EOC in administering state statutes.